Good evening, everyone. Thank you for joining us for the webinar about green card options for physicians. In this webinar, we will hear from Elissa Taub. And while everyone's still logging on, I just want to give a quick introduction to myself before we jump into that. If you don't already know me, my name is Peyton Jennings. I'm the physician engagement coordinator here at Practice Match. Some of the things that I do, a lot of the things that I do involve virtual career fairs and physician promoters, which if you're a promoter and you're on here, you probably already know everything about that. Hopefully, since you're here already, you know a little bit about what Practice Match and what we have to offer. We have multiple resources for you guys, free CVer builders, scholarships, virtual career fairs, the monthly webinars, free physician immigration handbooks, and career guidebooks for you guys. If you have any questions about any of those, you're more than welcome to reach out to me and I can give you any and all information that you might need. Like I said, don't be scared to reach out. Feel free to reach out to me. Please note that during this presentation, our microphones will be muted and we'll have time for a Q&A session at the end, as well as if you have any other questions. Elissa did say that she would be happy to answer them throughout the presentation. So just go ahead and drop those in the Q&A box or in the chat box for her. So now let's learn a little bit more about green card options for physicians from Elissa.
Great. Thanks so much, Peyton. And it's great to be here with you all this evening. Before we get started, I wanted to introduce myself and just kind of give you some information about what we're going to cover tonight. As Peyton said, my name is Elissa Taub. I am an immigration attorney with the law firm Siskind Susser. I am the head of our firm's healthcare immigration practice. And what that means is that my law practice is entirely devoted to the practice of immigration law. And within that, most of my clients, most of the folks that I work with are physicians. I also work with nurses and other, PTs and other affiliated or assorted healthcare professionals, but primarily physicians. I also am the co-author of the Physician Immigration Handbook that Peyton mentioned. And so I'm happy to be here with you all tonight to talk about green card options for physicians. This is, as you might imagine, a very broad topic. There are a lot of different pathways to green cards. And so because I want to cover as many of those pathways as possible, we're not really going to dive into the nitty gritty of what type of evidence do you need to prove X, Y, Z. Instead, what we're going to do is just give you a broad overview of how each process works and some things to be mindful of as you're making decisions or considering, do I go this way or do I go that way? And then kind of talking about some broad principles to keep in mind. I am happy to answer questions as we go. As Peyton said, you can drop them in the chat or the Q&A. I'll monitor them as we go through the presentation. The one thing I will mention is that, obviously this is not a confidential setting. This is not a one-on-one consultation. So please don't share any personal information in your questions, but I am happy to answer broader questions or questions that might be generally applicable. At the end of the presentation, I'll share my contact information, and you're always more than welcome to go to our website and schedule a consultation with myself or any of the attorneys in our firm who work on healthcare matters. So with all of that said, let's actually get started. So here is an overview of what we are going to cover tonight. We're first going to talk about the U.S. green card system overall so that we can be oriented about exactly what are we talking about when I start to throw out some of the terms that we're going to use tonight. And then we're going to cover the 5 different pathways to permanent residence that are listed there in the bullet points. And at the end, we're going to kind of talk about just some general issues and pitfalls, things to be aware of, timing-wise, backlog-wise, what happens if you change jobs, some of those types of things we'll get to at the very end. So if you've tuned into one of my prior webinars that I did for Practice Match on the visa bulletin, this might look familiar, this slide. I really like this visual when we talk about generally where are we in green card world? When we talk about a green card, we talk about these pathways, where are we? So I like to think about it like an upside down triangle where we start off on the top, that wide that wide top of the triangle there, where all of the green cards that might be available under the US system would be. As you all probably know, the US limits the number of green cards we can issue every year. Congress sets that limit. And then that limit is, it trickles down. There's some that are allocated to green cards that are obtained through the employment-based pathways that we'll talk about tonight. And then there are green cards that are allocated to the family-based pathways that we are not going to talk about tonight. That's sort of, marriage to a US citizen or through a sibling relationship or, your parents sponsoring you, things like that. On each of these sides, on the employment-based side, on the family-based side, there are green cards allocated. And then you see there some numbers. On the left-hand side of the triangle, you see 1, 2, 3, 4, 5. That represents the EB employment-based green card categories, EB1, EB2, EB3, EB4, EB5. And then on the right-hand side, you see immediate relatives, which is one category of family-based green cards, and you see 1, 2, 3, 4. Underneath each of those numbers, there are multiple subcategories. So to give you an idea, on the left-hand side, EB1, there are 3 subcategories of EB1 green cards. You have folks who have extraordinary ability in their field, EB1A, or what I refer to as EB1A. EB1B would be outstanding professors or researchers, and we're going to talk about each of those categories tonight. And then EB1C are multinational executives and managers. These are high-level employees that might have been transferred from another country to the United States to work for the same corporation. We're not going to be talking about that tonight because it doesn't really apply to physicians. So you can see that under EB1, though, there are 3 subcategories, and the same is true for most of these others. We are going to focus our discussion tonight on EB1 and EB2 and some of the subcategories under each of those umbrellas. Just wanted to use this to sort of orient us and talk about where we are in the world when we talk about green cards. So we're really, working our way from the broadest part of that upside down triangle down to the most specific. As we go through our discussion tonight, I'm going to kind of throw out the names of some forms. And for some of you, these form names are going to be really familiar, but you might not have ever thought about exactly what they do. And so I want to talk for just a few moments about the form names. The first form that's listed there on that slide, the ETA 9089, is a Department of Labor form that is what we use to file a perm labor certification. And we're going to talk about the labor certification process starting on the next slide. The labor certification is something that's filed electronically, and it's governed by the U.S. Department of Labor. It's not something that's governed by USCIS, which is the U.S. Immigration Service. It is, like I said, it's entirely filed electronically. Your lawyer, and this is something that we do in our office, your lawyer might send you a copy of it to review before they file it, just to make sure that your personal information, background information is correct on that form. And they may even have you sign a printed copy of it, but ultimately they're going to hit submit online, and the Department of Labor is that whole process is going to be electronic. I should mention that the ETA 9089 is not an immigrant visa petition. That's the form I-140, which is next on that list. This is important. I get this question a lot when physicians are going abroad to apply for visa stamps, and they go to file their DS-160, and there's a question about whether anybody's ever filed an immigrant visa petition on their behalf. If all that has happened is your employer has initiated a labor certification, or maybe it's even been filed, that is not an immigrant visa petition. You wouldn't answer yes to that question until you get to step 2, which is the filing of the form I-140. An I-140 is the petition form that is used anytime somebody applies for a green card based on employment. So if you are applying in EB1, 2, or 3, you are going to use an I-140. The companion form on the family-based side would be the I-130. If you were filing in the EB5 category, you'd use an I-526. So there are different forms that all get at the same thing. What that is showing that you are eligible for a green card in some category. On the I-140, there are, I want to say, almost like 10 boxes that I can tick off to say which category we are applying in. Am I applying in EB1A? That's box 1A. If I'm applying in EB3, I might be, checking off box 1E. If I'm in EB2, it might be EB, 1C, or 1D. There are all these different boxes to check off. That's how we tell the Immigration Service, since we're using the same form for all of these filings, that box check is how we tell the Immigration Service what they should be looking for in that filing, right? What category are we under? What rules govern this application? The approval of an I-140 is the government telling you, you are eligible for a green card in this category. And if your employer has sponsored it, they're telling your employer, you're eligible to sponsor this person in this category. So it's a key part of that process. And then the final form on that list is the I-485. The I-485 is your personal green card application. This is where your family members, a spouse, any children born outside the US who are under the age of 21 can also file with you. They each file their own I-485. And most of the time when we file an I-485, we're also filing it with two companion applications, the I-765 application for work authorization, or an EAD, and the application for advanced parole on Form I-131. Those three applications typically are going to be filed in one packet. They're each handled differently. You're going to get 3 receipts, one for the 485, one for the 765, one for the 131, but ultimately they get filed as one packet and then split up when they get to the Immigration Service, and they're each handled separately. So as we talk tonight about the different way, the operation and the way these different processes work, I wanted to make sure we just took a second to all be on the same page about what these different forms do as part of the application. All right, so let's dive in. The first category that we're going to talk about tonight is the EB2 PERM labor certification process. And I like to start here because in the law, this is the default process. This is what Congress, this is what the law expects any employer will do when they have an employee that wants support for a green card. The idea is that an employer is going to test the US labor market and show that they cannot find a qualified, available American worker for that position. That is what is done during the labor certification process. That is step 1. The labor certification, as I mentioned, is governed by the US Department of Labor, and through that process, there's generally 3 steps. The first step is that we're going to ask the Department of Labor to issue something called a prevailing wage determination to tell us what the minimum wage is that you're allowed to be offered for that job. Right now, those are taking upwards of 7 months to be issued by the Department of Labor. That is a really long time. While that's going on, and we manage the timeframes really carefully because this is a very heavily regulated process. While that's going on, your employer, through their attorney usually, is going to advertise your position. It doesn't matter if they previously recruited for the job, if there were old ads out there from years ago. All of the advertising has to happen within the 6 months prior to filing the application. And the place the place where the advertisements are run and the language that goes in the advertisements all has to be very carefully regulated, and everything has to be very consistent with each other. So we typically are running these ads. They're not in a vacuum because they do go off out into the world, but we are running them in a very controlled way for timeframes that are required by the regulations. It's very tedious. So we will do all of that. And then, toward the end of the process, after all the recruitment is done, after all the postings and notifications and everything are gotten through, your employer, through their attorney, will be able to file the ETA 9089. Now, one thing to know about the labor certification process is that it is employer sponsored. Your employer must pay all of the fees for the application, but it also means because we're advertising the job, the Department of Labor wants this to be an objective recruitment. If you, the employee, are heavily involved in this, that's not really an objective recruitment. So we don't really, the employee is not usually closely involved in the labor certification. It's usually something that the law firm and the employer are going to really handle together, and they'll give you information and share information about status and things like that with you, but you won't be the one, approving the ads or, actually running them, right? We want there to be some distance between the employee and this process so that it's all clear that it was on the up and up. Similarly, if you have a family relationship with the person who owns your practice or with your employer, that's something to disclose at the outset because that can actually complicate the labor certification process for this exact same reason. The process of the labor certification itself takes about 13 to 16 months right now. Most of that is because of the prevailing wage timeline. And then it also is taking the government a good 6-7 months to approve it. So all told, we're talking about over a year just for this preliminary process. Once the labor certification is approved, then we move on to the I-140 stage, and we would file your I-140 in the EB2 category. If you are a J1 waiver doctor and you're in your 3 years of service, that's as far as we get. Once the J1 waiver service is complete, and if you have a current priority date, meaning if you're an Indian national, you are not in, you know, you had a prior priority date or something. If you're not an Indian national, not a Chinese national, you probably will have a current priority date at the time you complete your J1 waiver service. So you complete the J1 waiver, you have a current priority date, you can file your I-485 for you and your family members. If you are an Indian national or Chinese national who is facing a backlog in the EB2 category, once the I-140 is approved, everything is going to stop and time is going to pass until someday that your priority date is current and you can file the adjustment of status application. That I-140 though will give you the ability to obtain extensions of your H-1B status if you need it way beyond the 6-year limit, so that you can continue to stay in the US and work while you wait your priority date to become current. So that's the interaction of those 3 applications: the ETA 9089 labor certification, the I-140, and the I-485. In this process, if you are looking to establish a priority date in that backlog, the priority date is established on the date that the labor certification is filed, and it locks in when the I-140 is approved, right? So if my labor certification is filed on April 1st, 2022, and the labor certification is approved on October 21st, 2022, and in November, my I-140 is filed, and let's say I file it with premium processing, and my I-140 is approved in late November 2022, my priority date is still from back in April of 2022, right? It's not November. It's still that April date. But it locks in for all time once the I-140 is approved. And that's important because your earliest priority date is going to govern you for the rest of the process. So that's basically the labor certification process. I think, you know, the important things there are knowing that your employer is going to really govern that process. They're going to control it. They have to pay for at least the labor certification part of it. So if you're, you know, thinking an employer, or if you've discussed this with your employer and they're like, look, we're happy to be supportive of a green card, but we don't really want to pay any of it, this process is not going to happen for you. You cannot pay the fees. You can't offer to pay them and be reimbursed. You don't want to reimburse the employer. All of that is going to, you know, exposes you and the employer to liability. We don't want you to be in that position. So those are important, you know, things to know. We're going to talk a little bit more about some of those things at the end of the presentation. All right. Next, the EB2 Physician National Interest Waiver. And I will say in my practice that is primarily, you know, devoted to working with physicians, these 2 processes are the 2 most common processes that I handle, the PERM and the PNIW. Most physicians are choosing between these 2 categories. The rest of the categories we're going to talk about tonight, I think of as optional, but usually we're going to go through one of these. The EB2 Physician National Interest Waiver is for physicians who make a 5-year commitment to work full-time in an underserved area. It sounds a lot like J1 waiver because it also has the word waiver in it, and it requires you to work in an underserved area. But make no mistake, they are not the same thing. If you get shut out of a J1 waiver through a Conrad 30 program in a particular state, filing a PNIW does not help you. It is only a green card application. What's being waived in this case is not the home residence requirement. What's being waived is the need to do the labor certification, right? We mentioned that is a default process. That's what the law assumes is going to happen. In this case, the government has said that physicians working in underserved areas is so important to the national interest of the United States, we won't make an employer do a labor certification for those doctors. One of the nice things about the PNIW is that it's self-sponsored. Your employer does not have to file this on your behalf. They do have to be supportive of the process. The initial step is asking the state in which you're working or a relevant federal agency, like maybe the DRA or the ARC, the Delta Regional Authority and Appalachian Regional Commission, if maybe you got a J1 waiver through one of those agencies, you may ask one of them to support a PNIW. And as I say that, I don't think the ARC does PNIW support, but the DRA does. To ask them to support your work in that underserved area as being in the public interest. That is a very important term, and it's an important letter that has to be issued by the State Department of Health or relevant federal agency. That's the first step, is getting that public interest letter, and then you file the I-140 with that in your credentials and your contract, your 5-year contract and all of that. A lot of times with PNIWs, we can file them faster than a perm, right? I don't need a prevailing wage determination that takes 7 months. I don't need to, wait on, there are lots of other things. We don't do any advertising. There are no, waiting periods that are imposed by the law or anything like that. So a PNIW usually can be filed a lot faster, several months, let's say, faster than a perm application can. So it can be something that helps you establish a priority date a little bit earlier than the perm. And a lot of physicians like the fact that this is self-sponsored because it takes your employer, once it's filed, it takes your employer kind of out of the driver's seat when it comes to your green card process. It gives you a lot more control over how things go. If you have a current priority date when you're filing that I-140, even if you're in your 3 years of J1 waiver service, you can file an I-485 right along with your I-140 when you go through this process. It is the one exception to the rule that says you can't file an I-485 during your 3 years of J1 waiver service. So a lot of the physicians I work with, sometimes they have a spouse who wants work authorization and they really aren't eligible for their own H-1B or don't have an employer to sponsor them. Going through the PNIW process, the spouse can file an I-485 and get a work card that way. And so a lot of times it can be a nice strategic filing to help your spouse get a work card, and then ultimately you guys end up being eligible for the green card. One of the big differences between the PNIW and the labor certification based case for folks who aren't from aren't from India, is that with the PNIW, you obtain the green card after you complete all 5 years of service. So essentially in your 6th. With the labor certification based card application, you usually are getting your card in year 4 if the process started during your 3 years of J service. If you're not a J1 waiver doctor, the perm process can go through within about 2 years. And the PNIW, like I said, is going to be closer to 6. So there's a huge time consideration there. And for that reason, I should mention that a lot of physicians choose to do both and cover both bases. I would say, I shouldn't say a lot. I should say it's not uncommon for physicians to choose to do both. I have plenty of clients who only go through the perm, and I have plenty of clients who only do PNIW. And then we have some that decide to do both. They cover both bases, or maybe they're using the PNIW in a strategic way to help a spouse get work authorization in the meantime while they're going through the process. So lots of options there, lots of things to consider with regard to the PNIW and the perm. And, there's a lot of things, as I mentioned, a lot of differences between the two that can really affect your decision to go one way, the other, or both. Now, of course, if you're not working in an underserved area, PNIW is off the table, not going to be an option for you. But if you are, or if you have a J1 waiver, there are some programs, some states that will, right at the get-go, if you sign a 5-year contract right up front, the state or federal agency may issue you not only your J1 waiver recommendation, but also might support the PNIW with the same letter. And then you can go right ahead and file that PNIW really early, even before you finish residency or fellowship, as long as your J1 waiver is approved. So there's, there are some real benefits to the PNIW process. And at the end, we'll talk a little bit about changing jobs and PNIW versus perm for that process as well. All right. I'm going to speed through these next few slides a little bit. We're going to go through them a little bit faster just because we don't necessarily see doctors filing as many of them, but I think it's important for you to have the information. And I should also mention, these first 3 slides, these first 3 processes that we're talking about, the labor certification, the physician national interest waiver, and the Danastar national interest waiver, if you notice, all 3 of them are EB2. If you are a physician from India or China and you are facing a backlog in the green card process in EB2, it's the same backlog. None of the 3 of these gets a leg up on the visa bulletin. They are all covered in the same spot. The Danastar national interest waiver, even though it has national interest waiver in the title, is very different than the physician national interest waiver. It's called Danastar national interest waiver because there was a recent last few years court decision called Matter of Danastar, is a USCIS AAO decision that established a new set of criteria for these types of cases. And so we use that case to modify it so it's clear what we're talking about. And basically, this is an application that is based on a person's work in a field that is in the national interest of the United States, that the work has substantial merit and is of national application, and that you are in a good position to advance that work. I like to think of this as you're doing really important work for the that's important to the United States, and you're really important to that work. You are essential to that work, and you're in a good position to make that happen. So we think about these sometimes with the EB1A, but this is not really based on your extraordinary ability. That's relevant, but it's really important to look at what exactly are you doing. If you're a clinical physician in a local practice and all of your patients, I'm sitting here in Memphis, Tennessee. If I'm a clinical physician here in Memphis, Tennessee, and all of my patients are here in Memphis or in the surrounding counties, am I really working on, in a field that's in the national interest of the United States? Is my work of national application? Yes, there's a physician shortage, but not every physician working in a local community is necessarily working in the national interest. Now, if I'm doing research and I'm researching in a field that's very important, I'm doing diabetes research or osteoporosis research or whatever it is, different issue, right? Then maybe you're contributing to research on a national level and you might be able to make out a case here. These cases are very fact specific. They rely on having support letters from folks in the field who can attest to your contributions and how important your work is and the national scope of your work. One of the things about the NIW, again, you do not need a labor certification. So you file the I-140 directly with the Immigration Service with all of the evidence. We usually include a pretty detailed legal brief with it to explain to the government how you qualify. Unlike with the labor certification case, the NIWs, the PNIW, and the Danastar NIW, right now you cannot file those with premium processing. It's coming. But right now, the government processing times on both sets of NIWs are over a year for those I-140s. They are slowly allowing folks to upgrade their cases to premium. When premium processing does come out for the NIW, it's going to be the same $2,500 government filing fee that's used for other types of premium processing, but instead of a 15-day turnaround, it's going to be 45. So it's still not going to be it'll be a lot faster than it is now, but it won't be a 15-day turnaround for these applications. I do not know exactly when the premium processing is coming. We know it's coming. I can't tell you for new filings when they're going to allow that. The government, USCIS, is really, managing this very slowly because they want to make sure that when they roll it out, they have the ability to live up to the requirement. So right now, no premium processing, but it's coming. I should mention also with any of these cases where there's no labor certification, if you're thinking about establishing a priority date, the priority date is the date that you file that I-140, and it locks in when the I-140 is approved. So the only case that's not like that, right, is the labor certification, where the priority date is set by the filing of the labor certification, not the I-140. So there's a little bit of a difference there. Moving on to EB1. We have talked about 3 different subcategories of EB2. We are now going to move into EB1, which is the highest preference category for employment-based green cards. And I want to mention the EB1B Outstanding Professor or Researcher category. This is an employer-sponsored green card process. It's limited in its application. I personally, I file them every now and again. Some of my colleagues file more because they work more with folks who are in academic settings. But the position that you work in has to either be a permanent tenure track academic position, professor position, or it has to be a full-time research position in an organization that, that has research as one of its functions, right? So they can't just say, oh yeah, you do research. There has to be a track record of high-level research coming out of that institution. Overall, there are 6 categories of evidence in the law that you have to meet at least 2 of. So a little bit lower standard than the EB1A, which requires 3 out of 10 categories. And then overall, you have to show that you are somebody who's outstanding in your field. So just meeting 2 out of those 6 criteria is not enough. You have to seem like you're outstanding to the officer, which is a very vague standard. And we do sometimes see that the government will say, oh yeah, you met the 2 criteria, but we don't really think that you're all that great under what they call the final merits determination. So it's a really important, part of the application. And like I said, it's very subjective. I think one of the things to know about EB1, both this category and the extraordinary ability category that we'll talk about next, one of the important things to know about both of these is that I can file 2 exactly the same petitions, like so similar, I can't even tell you, like all that was basically different is the name. And one will get approved with a no problem, and the other one, we will fight it out for years. I've seen this happen repeatedly. So, when you talk to an attorney and they evaluate your case and they tell you, yeah, I think this looks like the type of case that I have filed before. Based on everything you've told me, based on what we've looked at, I think that this is an approvable case. I think we have a basis upon which to file. That's a really great, that's something that you should appreciate. No attorney should ever tell you, I guarantee this is going to be approved. That's just not possible. The way that the government works right now, I like to say that the only consistency is inconsistency. So these cases can make you want to pull your hair out a little bit as an attorney, because you can file and you just kind of like send it out into USCIS world and hope that they see the application the same way that you do. So a few things about these outstanding professor or researchers. I mentioned that it's an employer-sponsored category, and I think sometimes people just assume, oh, EB1, I can sponsor it myself, but your institution has to be willing to sponsor you on this type of application. They don't have to pay for it, but they do have to be the sponsor. They do have to sign the forms. So if this is something that you want to go forward with, get buy-in from the institution, talk to your students and scholars office, talk with your program director, whoever it is, that's going to control, that really has the official control over immigration sponsorship for your institution. I know a lot of folks who work in-house at universities and colleges, and one of the things that really is frustrating is when a physician kind of goes rogue and hires their own attorney and has an entire application prepared, and then all of a sudden, brings an I-140 into the students and scholars office and said, hey, can you guys sign this for me? The school is probably not going to do that. And it's really not, it's really a good way to ruffle feathers. So make sure you have buy-in from the folks at your institution. They typically are going to have a list of attorneys that they recommend or that they have okayed for the preparation and filing of cases like this. And they probably also have a policy for when they will support someone for this type of application. So definitely talk with them before, you might go forward with something like this. Usually private employers, hospitalist staffing companies, private hospitals are usually not in a position to sponsor EB1B because the position, either they don't qualify as a research organization, or the position that you're working in doesn't qualify for this category. So it is very limited in application. I do talk with a lot of physicians who are interested in EB1, but the EB, they may not qualify for EB1A, and they look at the EB1A criteria. Oh, I only need 2 out of 6 and all of this, that looks great. But then when we talk about the position, we learn that the position really isn't going to cut it. So that's a really important aspect of these types of applications. You can premium process these. One of the things to know is that if you are, if you've completed your J1 waiver service or you're never a J1 doctor, You can concurrently file an I-485 with an EB1 I-140, whether in this category or the extraordinary ability category. I don't recommend it. And in fact, I don't recommend it even for the Danastar NIWs. And the reason is that these, as I've mentioned a few times, these are very, very subjective applications. You're relying on a government officer to read your application and agree that you're outstanding under their, very broad criteria. And so a lot of times it's, dependent on what that officer is thinking about that day, or what their knowledge level is of your field, or how much well they understand your application. If you concurrently file an I-485 with your I-140 in these cases, if the I-140 is denied, your I-485 will be denied. So that means all the fees that you paid, the medical exam you obtained, the passport photos you sent in, all of that will be wasted because the application was denied. If you decide that you really, really, really want to concurrently file, like there's some really, highly persuasive reason to do it, I strongly recommend that if you are in H-1B or O status or whatever it is, that you not let that lapse thinking, oh, well, I have this I-485 pending and I got my EAD and I don't need this H-1B anymore. Because if that I-140 is denied, as I mentioned, everything else will be denied. And so if you don't have that H-1B underlying everything, or that O or whatever your underlying non-immigrant status is, you're going to be left without status. I spoke with somebody today who's exactly in that position where they let their underlying status lapse. Danastar NIW was denied. It had been concurrently filed. Now the I-485 was denied, and she and her family are here without status. That's not really a place anybody wants to be. So, I really don't recommend the concurrent filing, but if you do it, make sure you keep your status valid all the way through until your green card is issued to, keep yourself protected. EB1A extraordinary ability. I think this is the category I get the most unsolicited questions about. So I'll do a green card consultation with a doctor who I've done their J1 waiver and their H1B, and they'll say to me, I really want to start the green card process. And I'll say, great, let's have a chat. We'll talk about how it works. And we talk about PERM and we talk about PNAW. And then there's always at the end, so do you do EB1s? Do you think I would be qualified? And I totally understand why. But I think it's really important to understand what this category is, that it's very challenging. And I have some strategic tidbits to share. So the EB1A extraordinary ability process is for folks who have extraordinary ability in their field. That means that you can prove that you are one of the very few who has reached the pinnacle, the top of your field. The regulations set forth 10 categories of evidence. You have to meet at least 3 of them, and you need to show that overall you are somebody who is extraordinary. It's a high standard. It is a very high standard. And we're talking about things, not just publications. Having multiple board certifications is largely irrelevant because if you are working in a specialty, subspecialty that requires those board certifications, that's just a minimum entry requirement to your field. It's not an honor. So keep that in mind. Publications are important, but they're not the only thing. We look at awards, we look at leadership positions, we look at peer review that you might have engaged in, whether clinical, journal, or both, whether you've judged poster presentations or you've judged other things in your field. We'll look at important contributions maybe that you've made to your field, leadership roles that you've held, if you're earning a high salary, compared to some of the salary metrics in your field. We're going to look at all of these things and determine, do you meet at least 3 of these criteria? If you meet more of them, if we think you meet more of them, we're going to argue as many of them as we can in your petition. Because just because I say, oh yeah, this to me looks like you've won this great award, doesn't mean that the Immigration Service is going to agree. I've had clients, filmmakers who have their films that they have made have won awards at film festivals, and the Immigration Service has come back and said that we didn't show that the award was for excellence in the field of filmmaking. So you can see that sometimes even what seems like common sense, the government doesn't always exhibit it. So we need to make as many arguments as we can to try to have the best chance at success. So that doesn't mean I won't file an EB1 that only meets 3, but those 3 better be really strong, right? We don't want to be meeting one just by the skin of our teeth. We want to really be feeling comfortable about those so that we could also meet the final merits determination to show that overall, considering everything, you're extraordinary. One thing to know, and it says it on the slide, but I'm going to say it loud and clear. If you have O1 status, that doesn't automatically mean that you qualify for EB1. The government applies different standards. They apply a lower standard to the O than they do to the EB1. And I have seen in some cases where the government has actually, I think, been harsher on my client because they're in O1 status and they sort of have this attitude like, oh, you think you're so great, you're EB1. Yeah, well, I'm going to show you what that means to have an O. It's not important. And it actually says in the USCIS policy manual that officers are not to take O1 status as evidence of being extraordinary. So it's really not, in the government's view, it's almost not relevant at all. We still have to prove the EB1 case. So it's really important to know that. As I mentioned with the EB1B, I don't recommend concurrently filing I-485s in this context. I think it's really risky. There's just no reason for it. A lot of times I will file my EB1A applications with premium processing. If they get approved really quickly, then we go ahead and, file that I-485, and that's great. I don't mind, I don't think it's too much to ask to wait a little bit before filing it to make sure that you have approval in hand before you go and expend all those resources on the 485 application. I know some lawyers think that that filing EB1A cases with premium processing is the kiss of death. I've actually had this conversation with colleagues. I don't see it. I see great approvals with premium. I see RFEs with regular processing. I see denials with both. I see RFEs with both in about, I guess, similar numbers. At this point, most of my clients premium process because the waiting period, the processing times that the government shows on these for the I-140s are so long that who wants to wait that out? Like most of my clients can't stand the suspense of waiting over a year to hear back on one of these applications. So I don't really have a problem premium processing them from the get-go. What I don't like to do is upgrade them after they're filed. I feel like that's asking for a little bit of too much attention. But if we file from the get-go, like I said, I don't really have any issue with the approval rates. I think they're the same. And I know some folks might disagree with me, but that's just what I see in my practice. Let's see. So, and I mentioned this is self-filed. So, obviously you have total control of this process. They take a while to prepare. I know it's one of those things where some folks think that an EB1A can just be pre-packaged. Like if I've done an EB1 for a client, for a doctor before, that I should be able to just like pre-package it and file it for another doctor. But your achievements and somebody else's achievements aren't going to be the same. I want to file an individual case for you. I want to make sure that it's specific to your practice. Now, of course, if you're an ortho spine surgeon and I have filed for an ortho spine before, well, we're going to have, some writing and some material that we can reuse, but that ortho spine's research or his publication, right, they're not going to be the same. So we want to make sure that your case is different than any of the other cases that we filed. Because if we're filing the same case over and over again, eventually the immigration service is going to notice. And then it's like, these cases might not really be legit. So we want to make sure everybody's got, is putting their best foot forward. So those are the general categories, what they mean, how they get filed, what the essential basics are. I want to spend just a couple of minutes on this last slide talking about some important issues. And I've mentioned some of these things already throughout the presentation, but I want to take a minute to really just cover these. The first thing is if you're in a backlog situation, right? So for the most part, this is our Indian physicians and our Chinese physicians. Establishing a priority date at the earliest possible opportunity is key. If your employer is open to sponsoring you in the EB2 category, but you have it as your ultimate goal to file an EB1 because EB1 is not backlogged, but EB2 is by a very long time. So a lot of my Indian clients, it is their personal goal to go through the EB1 category. That's great. I have no problem with that. Do not tell your employer if they are offering that you don't need the EB2 because you're going to go EB1. You don't want that. Have them establish your priority date. It would be usable if EB1 backlogs in the future, you can use that EB2 priority date towards your EB1. They're interchangeable. If you file an EB1 and it's denied, you still have the EB2 in the background. Nothing's going to happen to it. Make sure that gets established for you. The other thing I mentioned is if you're, a J1 waiver physician, you're just out of residency or just out of fellowship, even if you were not in a backlog situation, you wouldn't be able to get your green card until the end of those 3 years. So I look at those 3 years as sort of an enforced time when you can really be ambitious. If you want to file EB1, use those 3 years wisely, or about 2.5 or so, 2.5 to 3 of those years wisely, and get as much acclaim, have as many achievements and honors, as much recognition as you can, take on leadership roles, do all of those things in those 3 years, so that toward the end of those 3 years, you might be ready to file that EB1 based I-140. And then after you finish your 3 years of service, if there's no backlog, you go directly to the I-485 stage. There's no reason to file the EB1 I-140 your first year out of residency when you barely have been in practice a minute. Give yourself some time to make your way as an attending physician and then file. I find that those cases are a lot more persuasive. And since there's this enforced waiting period anyway, you might as well use it. And I even think for my Indian physicians facing 10 to 15 years or more of backlog time, like you have time, right? Whether you get your green card in year 4 or year 6, if those extra 2 years are going to help you make a stronger case, make a stronger case. You're still going to be ahead of the game green card wise, but you might have a better chance of success. So, really think hard and think critically about your achievements. Because like I said, EB1 is a tough category these days. I put on this slide here the link for the Department of State's visa bulletin, but honestly, if you Google, September 22 visa bulletin, and you look for the link that's at travel.state.gov, that's the visa bulletin. And even if you just Google Department of State visa bulletin, the most recent month will come up. You can check it every month. It comes out usually mid-month. So the September bulletin is already out and it's August 15th. It came out, I think, beginning of last week. We'll get the dreaded or anxiously awaited October visa bulletin mid-September. We don't have any idea what day, but sometime usually between the 10th and 15th is when it'll come out. I have no crystal ball. I have no idea what things are going to look like for October. It's the first time in a long time where I really can't give you an idea of what it's going to look like. It makes me a little worried because I usually get a sense. There are some folks that are thinking that things might go backwards. I don't think that's going to happen, but I do think things are going to slow in EB2 quite a bit. And from where they've been the last few years, but we'll just need to wait and see. About a month from now, we should have that bulletin and then we'll know where we stand. Changing jobs, and this is really important. If you have, some of the differences between the employer-sponsored and the self-sponsored petition. If you have filed, or if your employer has filed an I-140 on your behalf, they have sponsored you for that I-140, and you change jobs before filing an I-485, that I-140 is not really going to be usable, right? It's specific to your position, your employer, your location. So if you change jobs, you may need a subsequent employer to file again for you. And what that means in the perm context is that the subsequent employer would need to go through that whole process all over again to get you eligible to file the 485 based on their job offer. If you self-sponsor, so you go through PNIW or you do an EB1A, that doesn't apply. You have control, your employer is not in control of that. So you don't have to have new I-140 filed, with successive employers. I always like to say though, keep in mind, it is not required that you have an I-140 approved through every employer you ever worked for. So it's not like, oh, I went through the perm labor certification, I changed jobs, but I was at that job for only 3 months and I changed again because that was a terrible place. But they didn't file an I-140 for me because I wasn't there long enough. And now I'm never going to get a green card. That's not the way it works. The idea of having subsequent employers file for you is that when the time comes that your priority date is current or that you become eligible to file your adjustment, that you have an I-140 approved that is for the job you intend to work in when the green card is issued. So, you know, a job you held 2 or 3 jobs ago that you don't intend to go back to, you can't use that I-140 as the basis of that adjustment. So that's why you're talking about filing multiple, successive I-140s, not because there has to be a continuous chain. After you receive your green card, keep in mind that if that's an employment-based, right? So your employer sponsored you for that green card, the expectation of the government is that you're going to work in that job for some reasonable period of time after receiving your green card. You can't hightail it out of there a month later, right? When you go to apply for U.S. citizenship 5 years after the fact, the officer sees that you didn't really work in that job after getting your green card. They're going to raise some questions about what your intent was at that time, and that could really spell trouble. So best case scenario, you stay in that job for 6 months, or so or more after you receive your green card. Doesn't mean you have to stay there forever. It's not like you're permanently required to stay there, but you need to stay for a period of time. Oh, and I skipped the middle one there. What happens though if you need to change jobs while your I-485 is pending before your green card is issued? If the I-485 is pending for 180 days and you move to another employer in the same or similar occupation, you can port the green card from one employer to the other. But if you haven't filed the I-485, you just have an approved I-140 and you move, there's no portability there if the employer sponsored you. So that's where, the first bullet there, the second and the third, right? The first bullet, if I leave and I haven't been able to file an I-485, next employer has to file a new I-140 for me. If I stay and I file that I-485, I've got to stay at least 6 months to become portable to the next employer. And if I stay there long enough to actually get my green card, I need to stay there a little bit longer. So it's clear that my intent was to work in that position once I got my card. So that's the way that the hierarchy there of that decision making. And then finally, I want to mention a few things about the H-1B 6-year limit. As anybody on an H-1B might know, you are allowed to stay in that status for only 6 years. You get one for 3 years, you can extend it for 3 years, and then that's it. But there are ways to get beyond that 6-year limit, and that all depends on the green card process. So my recommendation typically is that a green card process of any kind, doesn't matter which one of these, but something needs to be started on your behalf no later than the end of your 4th year of H-1B time. That doesn't mean that you're going to necessarily have your green card in hand by the end of year 6, depending on what process you go through, but it does mean that there's enough time there to get you to the point where you can obtain extra H-1B time while you're waiting for your green card to come. And I listed in those last 2 bullets, if you have a perm or an I-140 that's filed at least a year before the end of your 6 years, you can extend for at least a 7th year and maybe beyond. And if you're backlogged and you have an I-140 approval at any time, you can get 3-year extensions beyond that 6-year limit forever until you're able to get your green card, or at least your priority date is current and you file a 485. So there are ways to get beyond that by using the green card process. So keep in mind, I know sometimes folks use H-1B status to subspecialize and do long-term fellowships, and they finish their fellowship and they're, at the end of year 6 with no green card filed, right? That, you really want to plan ahead of time to determine, am I going to file a Danastar NIW? Am I going to file an EB1? Or am I going to really pound the pavement and find a job at least, maybe a year and a half before I finish my fellowship, and talk to them seriously about the fact that I really want to come work for you, but I need green card sponsorship. And here's why it's urgent. I've done that with employers before, and it's worked out really well. So, really plan ahead if you're in that situation of kind of looking ahead and realizing you're going to run out of those 6 years. So we have reached the end of the presentation, there is my contact information. You have my email address. You have our website where you can actually go and schedule a consultation directly from the website. And then you've got our phone number. You can always call the office if you want to talk with a scheduler, with a paralegal scheduler to schedule something. But I really thank you all for your attention, and I will throw it back to Peyton.
Thank you so much for your time and presenting. That was an amazing presentation. I appreciate and thank all of you for attending as well. And if you enjoyed this webinar, we have another one coming up actually on September 6th, and you can sign up for that one just like you did this one through our website. And I will be sending that out after this webinar is over as like a thank you for attending and with that information in there. So does anybody have any last minute questions before we log off today? I didn't see any in the chat.
I didn't see any either.
I
was following it and I was like, but that's okay.
Well, thank you guys. Nope. Oh, we have one just pop up.
Of course. Okay. Let's see. Yes. So the 3 years that you spend in your J1 waiver commitment do count toward the 5 years on the PNIW. And actually anytime, so if you do your training in H-1B status, sometimes your time spent in training, if it was at an underserved location, can even count toward the 5 years. So the only time that can't count, just as a general matter, is time spent in J1 status. That won't count toward the 5, but time spent in the waiver service will.
I see someone raised their hand. Does anybody else have any other questions? Did you see that one?
Yeah.
Oh, all right.
Indian national refers to country of birth. So chargeability for the green card backlog is based on where you were born, not based on where you are a citizen. So if you were born in India and you moved to Canada and become a Canadian citizen, you're still subject to the green card backlog for India. But if you are an Indian citizen, but you were born abroad somewhere where you had the authority to be, essentially, then you are chargeable to the country where you were born.
Good question.
A few years ago, I was working with a physician who was an Indian citizen, but he was born in Iran while his parents were working there, and he was not subject to the backlog and was able to get his green card in the normal course of things, as opposed to, based on his Indian heritage. So even though he was an Indian citizen, his country of birth is what controlled there. No, the only time I've ever encountered a backlog for anybody not from India or China is the few times when EB1 has backlogs for everybody. And there have been a few times when EB3 has backlogs for everybody. And even EB2, it's happened a few times as well along the way. On the whole, though, those backlogs have been very short-lived. And ultimately, when those clear, unfortunately, because there's just such a long queue of Indian nationals who are waiting in this backlog, they're always still in there. So it sometimes crops up for others, but on the whole, if you were born in Canada, the likelihood of you facing a backlog in the EB2 category without some kind of change in the law is pretty slim. And then there's a question about I'm not sure I understand the question. Most of my clients apply for green cards from inside the United States, and a green card, to be clear, is the ability to, it gives you the ability to live and work permanently in the United States without having to constantly renew your status. And it also is the last step that you need to complete before you become eligible for US citizenship. So it's that next step on the pathway to becoming a US citizen. So it's something most of my clients apply in the US, but if you're outside the United States, there is a mechanism to apply for green cards from abroad as well. You can do an NIW through a relative's practice. So if you are working for a practice and your relative owns that practice, you can do an NIW because you're sponsoring yourself for that. The main prohibition on having a family relationship is in the perm labor certification context. There is actually a question on the application that asks if there is a family relationship between the ownership of the employer and the beneficiary of that application. And if you say yes, it's almost guaranteed that the Department of Labor will audit that application, and that is really difficult to overcome. But the self-sponsored PNIW can be a really good alternative in those cases. And also I should mention, and I think it's also part of this question, you can do a PNIW for self-employment. And I've done those before where a physician opens up their own practice and sponsors them and through an affidavit and through other paperwork shows that they're making at least a 5-year commitment to keep that practice full-time in an underserved area. And they've been able to obtain a green card through their own sponsorship that way. There are a lot of considerations there because of course you need to have work authorization and all of that. So it's important to plan for that carefully. But yeah, you can even own your own practice and do an NIW. So if both spouses are physicians, that question, if both spouses are physicians, when one gets a green card, does it apply to the other? You can adjust together, right? So one spouse can do an I-140 and the other spouse usually can follow on and apply for a 45 with them and get the green card at the same time. One spouse, but you each need your own I-485 application, right? Everybody gets their own green card, but you can go through the process with your spouse. You don't have to have your own independent application if you don't want to. I usually advise spouses, if they can, to each have their own process in the works because sometimes weird things happen. And if you can have multiple applications out there and cover your bases, it's not a bad idea to have some redundancy, but it's not required, ultimately. Wow, all these questions coming up. Let's see. I'll answer Sandeep. You get the PNIW, we always do self-sponsorship. I don't ever, it is very rare that I will advise an employer to sponsor a PNIW. Usually it's always done by the physician. And an audit, and when you do a labor certification, so let me take a different tack. When you file an application with the USCIS, sometimes they issue a request for evidence, an RFE, and they ask for more evidence in the application. They have a question about it, a question about your eligibility or something like that. With the Department of Labor, they don't do that. You file and either they approve or they deny. Occasionally though, they will audit the application. When you file, I mentioned that the labor certification is filed entirely electronically. I don't send them any copies of the ads that we run. I don't send them any copies of any supporting documentation. We keep that in a file in case we're asked for it through an audit, where the government comes and they check up on you to see, did you do actually what you said you were going to do, and did you do it appropriately? So when there's a family relationship, a lot of times the Department of Labor will audit the application, ask us to send in all of the supporting documentation, and then ask us questions about the family relationship and how arm's length the employment is. And like I said, they're really, really challenging in that context. Most of my physician cases don't get audited because there's a physician shortage. So it's not unusual that, an employer wouldn't have qualified responses to recruitment in that context. But every now and again, we get one randomly and, and we answer it, but it's not common. So the family relationship is definitely something that would trigger it. Well, thanks for all those questions. Those were good. They came at me really fast. But those were great, really good, insightful questions. Thank you guys so much for bringing those.
Yep. Well, thank you guys. And again, after this webinar is over, within 24 hours, this will be available on our website for you guys to go and rewatch. If you, again, have any other questions, or if you might have asked a question and forgot what the answer exactly was, this will be on our website. So thank you guys for coming, and I hope you all have a good night.
Great.
Thanks. Bye.
Bye.